Hopefully everything is working. How's everybody doing tonight? Hopefully y'all can hear me. All right, all right. The phone lines will be open soon. Probably be open in about 30 minutes. Hit that like button for me if y'all don't mind. Let's see. I'm gonna add the phone number into the chat, the call in number. Where is that call in number? Give me a second, y'all. I'm trying to add the call in number into the chat. There we go. Call in at 6 Central Standard Time and press 1 if you want to talk, if you have a question, anything like that. On a scale of 1 to 10, how good can y'all hear me? Because I think I might have did something wrong with my microphone, and I don't really know how good y'all can hear me. There is, what was that? There's a case. If y'all haven't watched the video, it's on my YouTube channel. It's called The Unlawful Arrest of Casey Neville or something like that. It's probably about a 30-minute video. And in the video, I just provide you with some commentary on how the police, they really unlawfully uh, entered this man's home, arrested him without probable cause or a warrant. They entered his home without exigent circumstances and his permission. Um, he needs to sue them. He definitely has grounds for a lawsuit. Um, if y'all haven't seen the video, I might just show it to y'all tonight on my since we live. I don't really know, but that was a clear example, in my opinion, of what a reasonable officer would not have done, because everything that they did is clearly established law that they cannot do in that video. So they are not going to get immunity. If they draft that complaint right, if he lets me draft that complaint, it's a wrap because they ain't getting out of that. I wouldn't settle that case. I would take it straight to the jury. I wouldn't settle nothing. I would take that case straight to the jury and I would hang them out and let the jury render their judgment against them, because that is patently, meaning clearly, unlawful. No reasonable officer would have done that. Can y'all hear me? On a scale of 1 to 10, how good can y'all hear me? I want to make sure that y'all can hear me. 1 to 10, how good can y'all hear me? Just put your number in the chat and let me know. Where now I'm gonna let me see if I can find some more information on this Casey this Casey thing. I found something on he beat that, according to him, he beat that case, by the way. He said he tried the case pro se and he beat it. So I found a website where I think one of the jury members on it. I think what is this? This is in Iowa. Casey, there it is right here. Casey Neville. Give me 1 second. I spelled his name wrong. I think it's Casey Neville. Here it is right here. Where? Nah, that's not it. Casey. Oh, I spelled this. Okay, yeah. Casey. I'm trying to see if I can find that link. The link description. It was they were allegedly somebody who was commenting on it was a member of the jury, and they're explaining the case. That ain't it. Marion County. I'm trying to find it for y'all. Once I find it, I'm gonna screen share it so y'all can see it. Casey Neville. Arrest jury. I think I found it right here. Yeah, this is it right here. All right. All right, I'm about to how much time we got? About 20, 23 minutes. Okay. So what I'm about to do now is I'm about to screen share this so y'all can see it. Give me a second. Let's get here. All right, y'all. So this is Casey right here. This guy right here. These idiots, these three idiots right here, allegedly. Now, if you watch the video, they're telling you in the video that he's free to, he's not under arrest, and he's free to basically terminate the encounter whenever he wants. So in other words, you'll see an officer in the video if you go and watch the video, a police officer in the video to this. They're sitting in the car. This woman right here, the man behind her right here, he's to her right, and they're sitting in a police car. And this man right here to her right, he says, well, I mean, he can shut the door in our face, because he's not under arrest. If he doesn't want to talk, he can just close the door or whatever. They say all of this before they literally go into this man's house. She knocks on the door. She asks him to come to the door. He comes to the door. As soon as he see this guy right here to his left, if I'm not mistaken, he say he needs to go, and she says no, he's not gonna do that. So as soon as um Casey realizes that this officer right here is not gonna go anywhere, he proceeds to terminate this consensual encounter, and they don't let him do that. He had every right to do that, but they didn't let him do that. They stopped him from closing his door and ran into his house and grabbed him, ran into his apartment or home or whatever you want to call it, ran in there and arrested him without a warrant, without probable cause, without exigent circumstance, all of that stuff. The only time that these people, generally speaking, can arrest you without a warrant is if they see you commit a crime in their presence. And they didn't see any of that. They didn't have a warrant. They didn't have a search warrant, arrest. They didn't have nothing. They literally went into this man's apartment and got him out, arrested him, and took him to jail. That's what they did. You cannot do that. That's unlawful. So let's go down here. Let's see. I'm gonna read y'all this. Now, if you go and watch the video, I mentioned in the video, I say, I stopped the video somewhere in the video, and I say, look, man, I'm not sure if Casey did this, what they're saying he did for real, but don't do that unless you have a legitimate purpose for calling for calling these people and reporting stuff, because they'll say you're harassing them or something like that, and that's what they did to him. But according to Casey, he had a legitimate purpose for calling down there because he was calling because of the there was some issues with his apartment that the I'm guessing that maybe the fire department or the city or somebody with that municipality is supposed to come down there and fix. And I'm guessing I don't really know this for sure, but I'm guessing he must have got fed up with calling down there so much, and eventually he just started cussing and got a little belligerent with him or something like that. That's probably what happened. But anyway, this whatever this whoever this is allegedly, I don't know if this is real or not, but allegedly this person right here say that they were on the jury. Says I was on the jury for the third-degree harassment charge related to this arrest. Afro man defended himself in court. The state's case was that he called City Hall a bunch of times wanting to speak to the mayor or city council members about the conditions of his apartment building. That's a legitimate purpose, depending on what the issue was, in my opinion. That and that he told one of the city workers that he had a God-given right to speak to the aforementioned officials and to do your fucking job. Now that's funny. The burden of proof the state needed to meet were as follows. I'm not sure if this is the correct statute, but notice this is a statute. That means as soon as you see a statute, that means you are not in a court created by the sovereign people of Iowa. You're in a court created by the legislature, a so-called court. It's not a court, it's an administrative agency, aka an inferior court of extremely limited jurisdiction. You're in a legislative tribunal. That is where you are. Okay? There are no statutes in common law, and there are no statutes in equity. There are only statutes in admiralty. Admiralty courts are civil law courts. Civil law is basically dealing with statutes and codes. That is the nature of the action. Anyway, let's get back to it. 708.7 harassment. So 1A, a person commits harassment when, with the intent to intimidate, annoy, or alarm another person, the person does any of the following. 1. Communicates with another person by telephone, telegraph, writing, or via electronic communication without legitimate purpose and in a manner likely to cause the other person annoyance or harm. Notice it says without a legitimate purpose. He had a legitimate purpose for calling down now. It says, and B, a person commits harassment when the person purposefully and without legitimate purpose has personal contact with another person with the intent to threaten, intimidate, or alarm that other person. The state failed to prove that he did not have a legitimate purpose in contacting City Hall and that he intended to threaten, intimidate, or alarm. So, in other words, these are the elements that the state needed to prove. The state had to prove that he didn't have a legitimate purpose. That's one of the elements. And they had to prove that he intended to threaten, intimidate, or alarm. Those are the elements that they needed to prove their case beyond a reasonable doubt. Excuse me. This is funny. Deliberations took about 30 seconds. The rest of the time, my fellow jurors and I spent talking about what a waste of time this was, and how it was a third and was it and how if that is third degree harassment, we all could have been guilty of it at one time or another. He's absolutely right about that. He's absolutely right about that. If what Casey did uh is harassment, then yeah, because like sometimes when you have issues with, let's say you filed a complaint against a police officer or something like that, and you keep calling after you file your complaint to get an update and to make sure that they're thoroughly investigating the complaint, and they just beating around the bush, and you called so many times to the point to where now you're just frustrated and you just like, you know what, F this, I'm tired of this, fuck this, y'all just do what y'all want to do, y'all need to do y'all fucking job. Such and such officer did this, such and such. I get it. I completely get it. Makes perfect sense to me. Let me read some more of these replies. Somebody asked him, what is his name? He says, juror number, not a chance in hell. That's a good response. uh, the only correct answer to that question, yeah, that's right. Typical dweeb. I don't know. Allegedly, that's what they're saying. I don't know if that's an actual juror or not, but whoever that is, they're making a pretty good case. A damn good case, if you ask me. That's
No probable cause, even if they have probable suspicion, probable I think so, probable maybes. If they don't have probable cause with the corpus delicti having like, hey, you just hit that person back there with your car. They don't have that. They don't lawfully, to me, for the letter of the law.
yeah, that's what's going on. That's exactly what's going on.
And now it's about your appeals. Oh, a civil matter. This is civil. We're just a civil administrative process. We did everything we were supposed to do, and blah blah blah. That's
Man,
basically what we facing. Because guess what? Any and everybody that's going to represent you in this, what I'm talking about, is going to be a bar member. They have to be a bar member. And that means automatically out the jump, there's a conflict of interest if the judge is going to be a bar member and everybody that's going to be representing the case on the opposition is going to be a bar member, and the person I get that's a stranger to me that don't know my case is going to be a bar member.
all
That,
of them, man.
to me,
All of them.
that, that's suspicious.
Every last one of them, man. Every last one of them.
So, I think I exhausted my state remedy. I got the Supreme Court to basically literally put it in writing. They said they were not going to entertain my writ of mandamuses. I was waiting for them to make some type of argument where I was wrong. They just basically said they wasn't even going to hear them. So if you're not going to hear, like, that poses a problem. But they know they're the highest court.
Man,
they know this situation.
Stuff like this is just it's going to keep happening. It's not going to stop until people just get pissed off. And it's the people's responsibility to check the government.
That's funny that you said that. It's funny that you said that because I've written the Attorney General of the country, Miss Vanita Gupta, which is the Department of Justice. And you know how slow they get along to getting anything. But this is my second inquiry toward the Department of Justice to come get involved in the state because I basically talk to every state official there is, from the governor to legislators to the captains and lawyers of the police department. It got to a point where I told the department or the attorney general of the whole country, like, look, I got PTSD. I'm just trying to deal with this. This court said this civil. This court say it's criminal. I already went to jail, but guess what? I ain't going to jail again for no traffic violation. One, because I'm operating under the highest court's authority of the state, and they said it's civil matters. So when a cop approaches me with any type of criminal intent in his voice, I'm gonna let him know. But after that, if it continues on, I guarantee you I'm going to equal my force, given his force trying to take me or my property to anywhere. That's just how it's going to go.
You got to be careful with them folks, man. Them folks dangerous because some of these folks really think that they are doing the right thing. They are just that slow. And they really think that people who think like me and you are crazy. But these people don't do no research. They don't read anything. They just believe what other people tell them. Police officers are not even, they didn't even exist at common law. Police officers are
Nope.
created via statutes.
Yep.
That's a
But
whole nother jurisdiction.
I think I've established enough paper trail and issues and lawsuits that if anything that did happen like that to me, one, let it be like, you know, paying it forward and taking one for the team.
Yeah.
But I would like to think that there's enough paperwork out there that all the weekend warriors that get on the computers and be on patient and be like, wait a minute, this motherfucker said this in one lawsuit and this county ended up killing, you know. I think there'll be a lot of paper trail out there talking about my fears through this corrupt process.
Yeah.
It's been well established. But if it did,
go ahead.
If it did happen, guess what, homie? I ain't promised tomorrow, no way. I'm already on borrowed time as it is. I ain't supposed to even be here. I'm supposed to be gone with my mama.
Yeah.
But my whole point is, while I'm here, is like I decided to stand up and fight instead of laying down and fight. I already seen how it was last time.
I feel you.
Last time I went to jail willingly, and y'all want to talk in your paperwork. Well, he consented. Oh, so you saying if I don't consent, that'll create what? An appealable issue?
Man, them folks down, boy. Them folks down crazy. I don't have no sympathy for them folks, man. When somebody go upside of one of their head or knock one of them off, I don't have no sympathy for them. Whoever knocked one of them off, I'm trying to figure out who they is so I can send them some bond money and try to help them with their case.
But see, I want to be an aggressor though because I'm gonna be handling my own video. But I am one that you ain't just gonna out strengthen me from my background and what I know I could do. But we're gonna grapple. We're gonna roll on ground. I'm gonna get you in a situation where you're gonna need your homies. Let's put it like that. Where you get your homies. Go get your homies. You're gonna need the homies. And I'm going to let you know before you touch me. Yeah, you better get your homies because you ain't cut out for that.
Man, they're a trip, man. But, don't let them label you a vexatious litigant. You don't want to get that title.
Well, see, this is the thing. They've already done what they've done. I remember I've been on live PD. I've kind of had like the spiritual path set for me, if you would say. Let's put it like that. I've been drugged through the dirt on purpose by God during these little encounters that's just intricately, just especially just in the gray area enough that if it went the wrong way, because I'm on live PD, I made live PD go off air for almost 2 years. And then they went on court TV. And then the moment, like, they threw out my lawsuit or whatever, they came back. And then I managed to find them hiding out in the back of a Richland County Sheriff SUV in the back part that pulled in the back of behind me in the Dollar General. And they was going after another brother who had a little paper tag in his vehicle who had just pulled up in front of me. And I happened to walk in the store, and the store manager knew the guy. And the store manager, I guess, was approached by the sheriff and was talking about they're going to arrest that guy as soon as he pulled up. They let the manager of the store know this. And I had asked the manager, who are they talking about? I'm thinking they're talking about me. Yeah. But they was talking about the other brother. So when they pulled off, and I happened to see who they had in the back seat, the manager confirmed, oh, yeah, they had live PD. So as a concerned citizen, I called my Richland County top brass, and I dealt with her. And she wanted to act like, well, we don't have nothing to do with live PD. And I go, excuse me, ma'am, I already sued y'all once, and I could sue you again. But it's not what you have to do with live PD. It's what your oath and your duty is to the community is what the problem is. Live PD is laying in wait to create situations to pull over citizens using your officers. Your officers represent us as taxpayers. They are servants to us. So are you. But if they're gonna hide, I said, man, if you have a problem with that, go. That's fine and dandy. Do not do nothing. Do not say nothing. When I see them hiding behind a car in the parking lot, waiting to land, I'm gonna make my own video and I will sue you guys again. Thank you very much. You have a nice day. And them bitches ain't been back to my county since. Yeah. And if they have been, but that's how we had to do as citizens. Y'all can make money off of all this. Y'all could create situations that's marketable like that. But the moment you trying to make them liable in the court, they like, oh, I didn't do this. Oh, I didn't do that. Oh.
Man, I got
like, wait a minute.
I got a case that's is bad. It's bad. He beat the case now in a motion to suppress hearing. He beat the case. So we just suing him right now.
You mean he beat the criminal case?
Yeah, he beat the criminal case. He said it cost him like 50 grand damn near to beat it, which is crazy. Cause they lied. It's a bunch of stuff, man. All they do is lie, man. Generally speaking.
But did he win in the trial? He won in the trial?
He won it on a motion to suppress hearing because they misrepresented materially false inculpatory evidence to a judge to secure a search warrant, and then they did the same thing to the jury to secure an indictment, and then they lied on the police reports.
It was all Brady violation.
Yeah, not only that, they the people who they the alleged witnesses, aka the complainants, who they talked to, who they allegedly talked to, they didn't even get them to testify at the grand jury hearing or the motion to suppress hearing, which is very odd to me.
So there's no affidavit.
That is very odd. Well, no, there's an affidavit for a search warrant, but it's the judge, he didn't believe in it. He didn't find anything that the officer said credible, and he said that they had no right to be on this man's property, and that they unlawfully searched his property, and so on and so forth. It's crazy. So
as long as he got the dismissal or the non conviction, that's lawsuit territory.
Yeah, he good.
And see, I'm figuring that out now because the way my cases is I was like Tupac. I borrowed first real quick. I just smacked them. I went straight to the federal government. They like, hey, you gotta go to the state. You gotta appeal this at the state level. You know what I mean? I took it all the way there. But
they say, like, if you're trying to sue them and there's a pending criminal case, or you have
you gotta handle that case first.
Yeah, you gotta handle that first. So they'll say your claim is Heck barred. It's barred by Heck v. Humphrey. Yep. So in other words, but here's the thing though. Let's say it's 10 or 20 years later, and then you finally get the case overturned and you get it ruled in your favor. You can sue them for that, for what happened 20 years ago.
Well, see, that's where I'm at now. My lawsuit, my federal lawsuit that got dismissed from federal court here in South Carolina, I appealed in the court of Virginia. Well, the Fourth Circuit had put it in that motion, what you just said, that Heck. So I just now got to the Court of Appeals and the Supreme Court to handle this case, and they're refusing to hear it, mind you, because they're considering it civil, and I got to pay the court filing fee.
Wait,
so
say that one more time. Say that one more time.
I can't appeal the case because they consider it civil, and I must pay the filing fee.
You talking about you can't appeal your civil case?
No, I can't appeal my criminal case. My civil case has nothing to do with my criminal case other than I'll try to sue the state troopers that arrested me.
I don't see how it's
that federal.
The only way that I can see that you can get a civil case out of a criminal case is, let's say you
No. See, you mistaken. The criminal case and the civil case are two different things.
I agree.
My federal case, I filed before the criminal case even happened because 2 years had passed during COVID, and these fools was ignoring all my motions at the lower court. It wasn't until I sued the lower court judge at federal court did this judge send all my discovery to a different address without my notification or anything, made a trial date, had a trial without me, and found me guilty.
Man,
Then
that's it's over. That's void. All of that's void. You mean to tell me that
well,
this
yeah, but
judge?
this is my point. Well,
You mean
no,
to tell me that
this is my
this
point.
was a criminal case, and this judge sent all of your discovery to the wrong address, and they had a trial without you, a criminal
Yes,
trial without you, and adjudicated you
yes,
guilty? Are you saying that's what happened?
yes.
Man, that's void. I ain't know what that shit is.
And
That is void.
well, hold on. This all happened 2 years after the original arrest because of COVID and all that, right?
Mm-hmm.
But mind you, I'm my own attorney in this case. He wanted to ignore me, ignore my motions so bad. Huh?
Go ahead, I'm listening.
He wanted to ignore my motions so bad and treat me like, I'm not going to respect you as no attorney. That the address that he sent all my discovery to, the person had put out an affidavit of facts. Like he said, "Oh no, these troopers came here. I argued with them. Like this is not this person's address. They want to leave it anyway, and they made me sign and give my driver's license. Mind you, I'm in jail at this time. When I get out of jail, I got that affidavit from him. So when I did the appeal, they didn't even want to put the affidavit in, bruh.
Man, they can't deny that unless it was not considered in the trial court or something like that. But
No,
you
bro.
could have made an
They,
affidavit, but they probably would have excluded that too. But you still had
I got it in, but they try to deny it. I got in sneakily because it was weird. My little appellate court, you know how those old lower courts are? They take recesses and make the little court last longer than that happened to me because she had to have another hearing.
okay.
And she trying to be, oh, sweet and baby, we in the South. And she tried to seem helpful, but end up she just playing the part. She trying to save the other judge. So when she went on this recess, she told me to get with the court clerk and go through all the paperwork, make sure we got everything, da-da-da-da. So when she left, before she had left, she had told me I can't bring that affidavit in. So when I met up with the court clerk, I went ahead, oh, you don't got this. So she's like, oh, okay, let's put it on the record. So I put it on the record. So when the judge came back, she didn't know about it. So
did they vacate
fast forward now to when I'm doing the appeal, they don't want the transcripts to hit the court because, one, I got the lowest court, the first judge committing Brady violations and crime. Like, one, I could prove he sent my discovery to a whole different address. He knew it. And in their argument of doing it, they tried to say the address was wrote down wrong by me because there's a N instead of a T. And they said I wrote the T differently. That's not even the case. The whole address itself is wrong. Like it's a whole different street, whole different numbers. Like y'all argument ain't even in the ballpark. What y'all talking about? So they're doing everything to save these two lower judges. Mm-hmm. So basically, now that I'm at the Court of Appeals and I made threats with them already, guess where? With the child support agency when I went to appeal my child support case. So the Court of Appeals know me very well, and they don't like me. Because guess what? I found 4 of the 8 used to work with DSS or family court or some type of child support agency DSS worker to some degree in their past. So I therefore called them all out by name and said, hey, in your own bio, you says that you work with child support and family court. Can you please recuse yourself because I would consider you in conflict of interests? Correct?
it's a possibility, but just because they work for these agencies, that doesn't necessarily mean that they would have been biased against you. Um,
Okay. But
I
if you
mean,
make that argument,
huh?
if you make that argument and you bring that up and you make a record of it and you make it public, what does that do?
What you bring? What up? The argument that I just said, or you
Everything
just
that
said?
you just said. Everything that you just said. I made all those statements. I made all those claims. It doesn't automatically make it so. But what normally happens when you do something like that? When you file something, there's a response.
Oh, okay.
They have opportunity to say, hey, that's incorrect. Hey, that's wrong. Hey, this and
Oh
that.
man, you
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 know what
see,
I'm
you want them
saying?
to play by the rules. They ain't finna. You can forget about that, man. They ain't finna
Oh,
do nothing.
no. I wasn't expecting them to play by the rules. I
Oh,
wasn't even
okay.
expecting a fair ball game.
Yeah,
I was throwing it in their face and letting them know exactly what time it is, what time I knew it was. Like, I don't expect this to be fair. Y'all got cleats and shoulder pads and helmets. Y'all gave me this basketball. Hold on, you hear what I'm saying? I
Boy,
might
you
be
a
a pro
fool,
state
boy. You a
litigant,
real fool, man.
but hold on. And I blew it out the water, and they just went ahead and just said, "Oh, we're gonna play this game. Oh, this is a civil matter. You gotta pay. You gotta pay." And the last time I paid for the child support case, they hurried up and dismissed the case. Like immediately, right after they waited till I paid. So they couldn't wait to dismiss it till I paid. Like by the time I got home, I got the dismissal in the mail. Like, God damn. And then they try to say, we don't got jurisdiction. But how do you not have, nigga, I just paid. Like, how do you know that already? And if you knew that quick, why didn't you let me know before I paid?
Oh, everything. Straight up.
So I had a taste of both of their left hand and their right hand. So I already knew what time it was. That's what made me do the writ of mandamuses. I was like, all right, I'm going to take this even above y'all. They ain't even acting right with me. Look. And then the highest court just said, you know what, we're going to stay out of that. But I'm like, hey, hold on, though. This is about a right. This is about it's a federal question. It's my right here. I have a right to appeal a case, bruh.
Yeah.
And you haven't established how I don't have that right. All you just said is I got to pay for a right. And if you're going to say I got to pay for a right, explain to me how that works. Because I ain't working right up here in the head to understand that when you just say that.
When you dealing with stuff like that, like if you're reading a statute and you're not really sure, then I would advise you to just go and read cases on it to see if what they're
I
saying.
had case precedent.
Oh
I
well.
had nine different case precedents from the highest court of our land in regards to pro se litigants filing criminal appeals do not have to pay for transcripts or filing fees. I had 9 cases, bro. 9. And all they did is like this, bro. They didn't even say, well, on the first one is blase, blase, blase. On the second, they didn't even do that. Because they're the highest court of the land and the judiciary here in this state and in Virginia get to do in-house oversight without nobody having any peeks at what's going on. Mm-hmm. They just said, we are not going to even entertain that. And what you going to do about it? We the highest court of the land we make. So now I got to go back to the federal court and bring to them how it's my right being violated here. My right to appeal is a right to protect the right. They don't say nothing in that.
They don't play. They don't play fair. They try to wear you out. They try to make up all these excuses. I had a judge one day. I get he wasn't expecting me to know what was going on, and so when he realized that I knew what was going on, he ran out of the courtroom, and he sent the damn state trooper in there to scare me. told me they was gonna hold me in contempt of court for showing off the judge or whatever. I don't know what they got going on, but anyway, um, long story short, I didn't pay that fee, and I ain't had no warrant issued for my person. So I must have said or did something right. But they did try to scare me though. Yeah.
Well, see, I'm kind of in a limbo like that right now. Like, so since all my cases and all this had all started years ago,
Mm-hmm.
since then ain't no new one started, ain't no new cases came up, ain't no new arrests. You feel me?
Yeah.
you feel me on that? And
Yeah.
we kind of got it to where you stay over there, I'ma stay over here. I haven't gotten to a situation just yet to validate and make sure that's 100%. That's what it is. But let's put it this way: when I live my life, when I leave my house, I leave my house with the intent that this could be that one last day. This could be that one time. You feel me?
Yeah, I feel
And
you on that.
everything that
That's
I
true.
play in my mind
That's really true.
is to play in my head exactly what I want to say, what I want the jury to hear, what I want them to see when I'm holding my video camera. And I want it to all be according to the exercise of a right. I want it to be coherent. I want it to be non-threatening, without anger, but loud enough and coherent enough to be properly and reasonable articulated for the ear to hear that, yeah, that brother right there.
Yeah, he know what he talking about. That's what you got to do with these people, man. You have to really, when they start asking you questions, are you a sovereign citizen, and start saying that you need a mental evaluation. Well, if they did that to me, I would say, Your Honor, I don't know what I'm talking about. I'm just repeating everything that your colleagues are saying. So if you want to call me crazy or call me a sovereign citizen, then essentially you're calling your colleagues crazy and a sovereign citizen, because the only thing that I'm doing the same thing that you're doing, Your Honor. Everybody state opinions, because don't nobody know the truth for real. The only thing that they're doing is repeating other opinions of other judges, so-called judges. That's all they're doing all over the goddamn country.
But what we
Opinions.
got to do is flip it right back on them. It does not matter what you believe that I might be. What matters is, what are you being paid to do? Your duty and your efforts of your servitude, everything that you do to service me, the sovereign, however you might want to view that, it is what? Moot.
It's
Right?
irrelevant.
It has nothing to do with what you will to be doing, right? So let's really just put it. We gotta learn how to put that shit right back over there in your court.
I agree.
Right over
I
there,
agree.
buddy.
I'm not answering any more questions. When they ask me a question, I'm gonna ask their ass a question. That's what I'm gonna do. I'm
Well,
not giving them
with the
no answer.
bonds,
Huh?
you know how you do the bonds, so you're familiar with the bonds. We know this. So what I've been trying to do is get into a dialect with them where I start off the situation like, look, sir, I'm going to offer you the most utmost respect. How's your evening doing tonight? Hopefully it's good. Hopefully it continues to be that way.
Mm-hmm.
But this can go two ways, and hopefully it can go the best way for both of us. So tonight, all I have to say is I'm going to be leaning this way. I've been making efforts to handle this way in the best way possible in the courts. And as you know, these courts are not exactly fast. But what I'm doing tonight is nothing criminal at it at all. And you will be able to articulate that, and your mind should be reasonable to see that that is a fact. So tonight, I want to know, if you proceed to go any further without my consent, I would just want, according to state law, South Carolina States 8-3-230 states that if I ask for your surety bond, you must produce that. Can I have that tonight if you're going to ask me for anything else from here on out tonight, sir? And I kind of want to get into into where they make their reasonable choice to go forward from that part. Because if they do go forward, You know, they always trying to go all the way in. They in the paint.
That's
So you
good that
better
they
just be
actually
quiet on that
require
one.
that.
Just let them do what they do. You feel me?
That's good. I was
Because
gonna
they're not
say.
going to give you the policy number.
I was gonna say that's shocking and good that they actually require them to give you their surety bond once you ask for it. I'm shocked that that's
Yeah,
even.
yeah,
You must. Are you reading that statute
yeah. In
right?
our
No offense, but are you reading that
yes,
statute right?
correctly, absolutely. Hold on, I'll even give it to
That's
you so you can look
crazy.
it up yourself.
That's crazy, man.
You didn't. You never heard of that? Every state has it because every state that deals with state tort laws has that.
No, I didn't know that. I got to check that out because I didn't know that. I'm shocked. Like I'm very shocked about that.
Hold on one second. I'm looking it up now.
All right. That's good though. That's what you need. They don't have, man, look.
But what
Huh?
the reason why I say that is because I'm filming. And if you film yourself asking a public servant for their bond and they refuse, that refusal is against the law.
Oh, so it's some sort of criminal action or something like that.
Well, it's a requirement in order for any public service worker to work in public, they must be insured. And that insurance bond is to be sued upon. And on request, it should be furnished. Hold on, I'm still looking for it.
All right. Let's
I
see.
used to have it saved on my phone, but it just clogged me up. My phone runs slow, so I erased a whole bunch of stuff. But hold on, I'll get it for you.
All right.
8
If you have any questions, just and when you call into the show, just press 1 and I'll turn your microphone on. Let me go to this chat. I finally was able to fix the volume so everybody can hear it. It says they're all contracts of child support. Yeah, I agree with that. Yeah, it's also malicious prosecution too, Jr. The guy's case, man, I have probably about maybe 20, probably about 22, 23, not over 24 causes of actions each against these police
Okay, I
officers.
got it.
All right,
I got it.
go ahead.
So if you look up, just Google South Carolina
All right.
Code of Laws 8 3 220.
South Carolina.
And not only 220, you got 210, 230, 240. Basically, that whole code speaks on the bond, but that's where I'm talking about where if you request it. So 8-3-210 is the one I'm talking about.
Okay.
So state officers and employees shall advise interested persons as to bonds and furnish copies. Any officers, agents, servants, or employee in any office in the state or any of the
Of its boards,
boundaries or
bureaus,
bureaus or
department.
departments.
I see it. Commissions or other instrumentalities upon request therefore by any interested person shall supply such person with information as to whether any person employed in any office, board, bureau, department, commission, agency, or other instrumentality of the state is bonded for any purpose, and if so, furnish such interested person with a copy of such bond. State officers
Read
and
the next one.
220.
Read the very next one. Yep. Read the very next one.
The bond of
Just the title.
the bond of any public officer in this state may at any time be sued upon by the public, any corporation or private person aggrieved by any misconduct of such public officer. Certified copies of bonds delivered to parties to suit on request for the purpose of any suit brought under section 220 of the 83220, the officer or officers, for the time being, with whom such bond may be filed or recorded upon application at his or their office, shall deliver to any person applying therefor and paying the fees for doing so an exact and certified copy of the bond. So it seems like they're required to register this bond or deposit this bond in somewhere locally, maybe, to for it to
Well,
be on record or something like that in section
I,
230.
I know my sheriff's department is different than the city police department. So
Okay.
you got some departments who are required to have surety bond blanket coverage. Then you got some of them who might require individual insurance. So if you're employed with us, you're going to have to go out and go get your own insurance for your own surety. Here's a list of the sureties in our county that does those, and you're going to have those in order to work in our county, correct? So
Sounds about
what
right.
I'm saying is you're turning this into a tort claim action with all the wording that you would need for that insurance investigator to come see about your claims and when your claims is, because one of the requirements to having surety insurance is what? It's the most important thing.
You said one of the what?
The most important things of having surety insurance. The bond.
Okay.
What's the most important thing of having that?
Hold on.
Huh?
I'm a little lost. What we getting at? What's the question? I'm a little lost. I'm sorry.
So if you're a police officer working as a police officer, you're required to have insurance to be a police officer.
Oh, okay.
What's the most important thing about that insurance?
It needs to be I think it has to be a certain amount. I'm not
Well,
sure.
no, I don't mean to that regard. I mean to the regard of the insurance company.
I don't know. I
The
don't
most
understand.
important thing.
I don't know. Go ahead and
The
answer. I
most
don't know.
important thing for all insurance companies is to not pay out any claims, correct?
Oh, okay.
They don't want to pay out nothing.
Or pay as less as
They
possible.
want to, yeah, their whole goal is to have zero claims and zero accidents this season from anybody, correct?
Zero accidents. That's what I was trying to get
Yeah,
people to understand, man. When you suing them, it's a claim. It's an insurance claim.
exactly. So my whole point of that is you're recording this officer and you're recording him and his response to your question of his duty to answer you about what? His insurance.
Mm-hmm.
And what his insurance company requires him to say? Here you go.
Oh,
Because
okay.
the moment they deny it, guess what? They violated their own insurance policy
Oh, okay. I see
by
what you're
mere
saying.
denying it. It says it in their policy. Whenever this is asked for, give it. Like, you are outside of this. This is up to us
Yeah,
now.
let me
The insurance
hold on
company
right
have
quick,
their
Trey.
own ways of dealing with it.
Hold on. This is a damn insurance claim, man. When they
Yeah,
violate your rights, that is an injury. That's what they call an
yeah,
injury. And
yeah.
as a result of you sustaining that injury, let's say they violate your Fourth Amendment.
Well,
Huh?
they're called a tort feeser.
Yeah, tort fees. That's what they call them. They call them tort feasors. Um,
Because this is a tort.
yeah, it's a
This
tort.
is all
This is
torts.
I'm gonna
And
tell y'all
when
something
you're
that y'all
dealing with,
probably don't know. 42 section 1983 lawsuit it's a quasi common law lawsuit. The reason why I say quasi is because an action at law, I mean a remedy at law is money. You're asking for money, but there is no fucking money. Not only that, you're doing it under a statute, and ain't no statutes in common law. So what I'm trying to get you to understand is you can do this same shit without using statutes. But they don't want y'all to know this shit, man. They don't
your Bill of Rights,
they don't
your
yeah,
Bill of
it's
Rights.
the
You can,
Constitution. You can use an
You use
article
your
of the
Bill of Rights as
Constitution.
a cause of action.
Huh?
I was denied this right. You use that as a cause of action. I was denied my Sixth Amendment right, and this is how.
Yeah.
I mean, that's a cause of action.
How you would do that is you would invoke a court's original jurisdiction under the Constitution, not under a statute. So when you do it under the Constitution, the court is in its proper status. Now it is actually a sovereign administrator. It's an agency that was actually created by the true sovereign, which is the people. It's a superior court of general jurisdiction. Courts of general jurisdiction hear all cases. They hear cases at law, in equity, maritime, and admiralty.
But see, this is what I'm saying about this whole tort situation. This is where I'm trying to get better at it. Where we're talking about this and that state law that I gave you to look up, and this insurance, we're talking about state tort claims. State tort claims are handled at the circuit court. You file state torts, and when you file a state tort, the insurance company comes and contacts you.
Yeah,
and you go
an insurance claim. You're right. You're right about that. Makes sense.
Yeah,
it's an insurance claim.
So what I'm saying to us at these traffic stops when we're dealing with these courts who don't want to one, establish the right to travel or to rule on any type of common law. They all want to go to their administrative quasi whatever direction.
They want to keep it at. That's what, because they don't have no power in there.
This is my point.
They don't have no power in there. But it is perfect. I'm telling y'all right now. There are court. I'm sorry to cut you off, Jerome. I'm sorry, man. There are common law courts. A court of general jurisdiction, or what they call it. They call it superior courts, or a court of general jurisdictions. It's the same damn thing. How you invoke common law jurisdiction is you file a declaration at law, which is a common law complaint or whatever, and you so-called pay the filing fee in gold or silver. That's all you doing. And you doing the same shit that you do in a 42 section 1983 lawsuit, except for you're not alleging some sort of statutory jurisdiction. You're invoking the jurisdiction under the Constitution, as opposed to
you're talking that federal court. You're talking that federal court.
Both of them, federal court and state court.
Yeah, you can bring an 83, but it's better to do it at the federal court.
What I'm saying is, you don't need statutes to do any of this shit. That's what I'm trying to get people to understand. But they don't want y'all.
Well, yeah, that's what I'm talking about. That's what I'm talking about. I'm talking about a whole different thing. This ain't even about. All right, so we're bringing it even out of like even the Constitution and the rights, and we're bringing it out even outside of that. Even what we're saying, what I'm trying to establish here is before a cop can even be a cop and be out there in your face being a cop, saying the cop stuff that cops say. If you understand what this state law requirement for your cop to have insurance and to know that policy and to give it, if you make a video asking for this insurance, quoting this law and everything that's involved with this insurance policy, with this cop on a video at a traffic stop, you should be able to win any insurance claim. And what I mean by that is if you make a tort claim and you go after his insurance and not make this a lawsuit situation like your rights or anything other than the rights he violated during that traffic stop, if you make it just like this claim, this insurance company has every right to fire this person. Matter of fact, everybody that really gets a claim on them, they drop you anyway, automatic, because you're a liability. Yeah. So they automatically do that.
Like car insurance, man. It's the same exact thing. That's all it is.
Yeah.
Man.
So my point is to try to be like preemptive when it comes to having to sue a motherfucker. You can be preemptive if how you're doing is very nicely, very politely, and then it could work its way into a federal lawsuit if they decide just to whoop your butt on camera on a YouTube live or something. You know what I'm saying?
Yeah.
But I'm just saying to get more preemptive on what they supposed to be doing, Craig. You know, you all up in my face what I'm doing, what you supposed to, you feel me?
Yeah.
Because going to their courts, you already see the size. They, like I said, they ain't even playing the right sport. These fools got on spike cleats. They got pads, helmets, face masks. They, you know what I'm saying? They just gave us a volleyball, dog.
Yeah, man.
They threw us over a wife beater and said, "Here your jersey." They not trying to play fair. They're not going to play fair, and you got to get them in some extreme situations. You got to file extremely clear and logical. It's so much more difficult to go the other route versus what it is you supposed to be doing, Craig. Because just this one little thing, there's like five little things I got to memorize for said cop. And you know what? They might not work in the criminal aspect. I still might get arrested anyway for whatever reason. But my point is, as long as I got a video of this that I can send to the insurance investigator, and that investigator could say, well, he was asking you for the insurance, and part of the policy is you have to disclose that insurance. So,
that lets you know
you feel me?
All commercial, man. They all corporations. If they not corporations and this is not commercial, why do they have insurance? Because all of them have insurance.
And this can go on and on and on and on and on. Everyone you come across. So you get arrested and you go to jail. And then you're going to have your arraignment. And guess what? There's going to be a little magistrate, administrative pretender up there talking about do-do-do-do-do. You're going to be like, sir, according to the law of 8-2-da-da-da-da-da, what it is you supposed to be doing? You feel me?
I got another caller on the line, man. They been waiting.
Go ahead, bro. I wanted to touch base on what you were doing with that appeal, so I can bite off anything.
I'll let you know. I'll let you know what happens. You know what the disposition was. Once I get it back, they probably not gonna rule on it until probably about next year, maybe, or something like that. But I'll let you know.
Yeah, they are slow. They are slow.
Yeah.
But I appreciate your time, bro.
All right, man.
You take it easy.
Same.
All right. Late.
All right. Caller 2872. Good evening. How you doing?
Good evening. How you doing?
I'm good. Go ahead.
I had questions in regards to the last caller in regards to a case that I have going on currently, but I was curious about that state code that he's talking about with these bonds, because that's a major issue that I'm having here in Kentucky. It's a lot of dirty attorneys, dirty judges, and they refuse to give you the bonds information when you ask for it because they know that you're going to file a claim. Mm-hmm. And when you file a claim against their bonds, it means that you out of here, especially when you can prove that you all are committing crimes on government property with American flags with gold fringes, and it's people with certain skin color. So I was curious to know about the code that he just said that's by state, because if that's in that state, that means every state has a code that says that.
Well, it's not.
So I want to know that code.
It's not in that. I mean, that particular code is not in every state, but that verbiage.
I know it's not going to be that particular code, but each state would have their own code.
Yeah, you got to go on a wild goose hunt to find that, because when
what was it? He was saying it was something about a surety bond.
Yeah, they have bonds. They either some of them are gonna have. I'm not sure if you looked at the videos on my channel, but I show you. It says.
No, I just want to know what was he saying to where I can research it. What was the key words? What was he saying? And what state was that he was speaking of?
I think it was. He was talking about South Carolina. And
South Carolina. I couldn't pull up that code.
You say what?
I couldn't pull up that code for South Carolina.
It's in there. I
My
just
main
read.
question is
Go ahead.
for the 42 1983s.
Okay.
These lawsuits. Do you post things to help write the summons and the certain procedures that have to be followed when you have those cases? My problem is not my understand. I have very good understanding of the law. My problem is formatting those motions.
I think I did probably about 3 videos on it. So
Okay,
it's
I'll have to go for your videos.
yeah. Let me see if I can find the video. They very easy. All of it is easy. It is all don't once you realize how easy this is, you're gonna be like, damn, it's like that. Yes, it's just like that. They very easy. Let me see if I can find the videos for you, because I think I did about 3 of them. I'm gonna post them into the chat, the links.
Okay. Yeah, because that was one of my main questions. What he just touched on was going to be for the claim that has now made it to the federal courts. Is that I have issues with the bonds information. When you ask these public officials, these public servants for their bonds, and they tell you, some of them try to tell you that they ain't supposed to have one, and yes, you are. Here's your own code that says you are supposed to have one, and here's the Constitution that says you're supposed to have one. How they send you around, they put you on all these wild goose chases, and it's really good for you to document it and record it so that you can have that proof, that I was asking for this information from here, and from these people who are supposed to have these bonds, and you have no luck with these bonds, so you're forced to go to the federal court because nobody wants to give the insurance information for the claim to be filed.
Yeah, that's how you're gonna get it. When you file that claim against them in federal court, that 42 Section 1983 lawsuit, and you ask for it, they call it indemnification or something like that, an indemnification agreement. They gonna give it to you. They gonna dance around the bush. They might give you, like, this is how they did me when I asked for it. They gave me everything except for the one piece of paper that I needed. So I had to look through all of this damn paperwork to see if they gave me everything. And then when I realized they left out one, I had to call the attorney and send him an email or something like that to get it. He eventually ended up giving it to me. He did that on purpose, because that ain't no mistake. That ain't no mistake. You gave me all the rest of them except for the one that I need. I'm adding the links to the chat. I'm not sure if you're seeing them, but it's
Okay. I'm gonna look, but that was gonna be my main question for that case, was the formatting of the motions and the question regarding the bonds. When you're asking for these bonds, that these public officials, servants, are supposed to have these bonds, and you can ask them for the bonds, and they'll flat out either tell you no, or we're not supposed to have them, or they'll tell you to go to places that really have nothing to do with who, the person or the facility that would house their bonds.
well, some of
The sheriffs here in Jefferson County told me that they don't even have to have a bond, and I know that's a lie. You got to have a bond. You got to have some type of insurance.
Yeah, some of, I'm gonna say most of them do. It depends on, like, if they are duly elected public servants, like somebody from the school board, like a clerk for the court. In other words, what I'm getting at is, if if the people have to vote them in or something like that, if they're actually running for an official public office or something like that, generally speaking, they're gonna have to have a bond. It's just a requirement now. Real common law officers, I mean, they can hold their positions without bonds. Like a sheriff doesn't really need a bond. They do have them, but they don't really need them. I mean, because the legislature, if I'm not mistaken, created that bond, if I'm not mistaken. But they do have bonds. All of them don't. They are not allowed to have their own bonds on them. They have to register their bonds somewhere in the public registry, like a Division of Risk Management. That's one name for it. Or I think in Indiana they don't call it risk management. I think they call it the Department of Insurance or something like that. They have, some of them have their own separate bonds, and some of them, not some of them, a lot of them are covered under one bond, in which they call a blanket bond.
Okay.
So it's a little tricky. It's hard to find that stuff. I'm not gonna lie to you. It's hard to find it, but they do have them. Don't let their ass lie to you, because they
Yeah, but
will
it's
lie.
not supposed to be hard to find that
No,
when
it's not.
you're
It's not supposed to be hard.
interacting with a public servant, and when you ask for it, it's supposed to be given to you. It's
I
just like an
agree.
attorney, a judge, any of them. When you ask for it, it's supposed to be given to
Yeah,
you.
I agree.
First of all, you need to prove that you have the authority for this, whatever proceeding that we're in. If we're in this courtroom, then you need to prove to me that you're an attorney. I need your oath of office and your bond. And majority of their oaths are deficient. They're not even the proper oath. Don't have no seal. Did nobody execute it? It just says judge. The judge of what? I mean, it's just,
Go
and it
ahead,
makes you wonder who's running the insurance company that they have their insurance with.
man.
It's major. It's serious. It's heinous crimes.
I agree.
It's RICO crimes. I mean, it's so much. It's so nasty that it don't make no sense.
I agree. And they just keep on doing it and keep on. I seen some people. I was going down the I was traveling down the road today, and I saw these two older black women out, and they had all these signs out telling black people to protest because the police here, they done shot and killed somebody, but don't nobody really know about it. I didn't even know about it. They just swept it under the rug or whatever. But these women, I'm assuming that this is their son or nephew or brother or something like that. They know about it. They had signs posted all around up and down the highway, but people are just passing by, just not paying attention. It's sad. It's like people just don't care. They just, unless it's bothering them, they just don't care until it's affecting them. And I hate that shit. It gets on my nerves. It really bothers me. It gets on my nerves. And I'm not the type to protest. Yeah, I'm not finna protest. You might as well just leave the city if I got a problem with you. If you're a public servant and I report you and they don't do nothing to you, you might as well quit your job. That's all I'm gonna say. You need to quit. But you won't do it to nobody else.
Yeah, because you a threat to the public. You know, like this is some serious stuff. It's really bad, and like I was saying, my issue was with the formatting because I understand the law, but to format it and make sure that I got this stuff bulletproof to
It's
where
it's
we really make something shake because
it's
it don't
it's
make no
easy.
sense.
It's easy. I promise you, it's easy. It's easy. If you got the law, then you good. If you know how to apply the law to the facts of your case, you good. The format and all of it's all the same thing. All of it is the same exact thing. It works the same exact way. All of it.
Okay. All right, but I thank you. I thank Jerome for his talk and his resources, and I thank you for taking my call and answering my question.
You're very welcome. Very welcome. Okay. All right. Let's see. Caller 4481. Good evening. How you doing?
Pretty good. How you doing?
I'm good, man. Just one day at a time, man. What can I do for you?
I was wondering, as far as criminal investigators, if I could ask a question about that.
Go ahead.
You know much about the United Nations Criminal Investigation Divisions?
No, I've actually haven't heard of it, but it wouldn't surprise me or shock me that they would have some sort of administrative agency like that.
Because I was wondering how, like, what a criminal investigator has to do. I don't know much about it when it comes to them going into dangerous territory and stuff like where they protect the public and protect themselves. You know how criminal investigators anywhere, federally or state or internationally, would, you know, how they would protect themselves and how they, you know, do prosecution and stuff like that.
I'm assuming that would. I mean, it seems like it would be very similar to a detective. You say a criminal investigator, so it's like they're investigating potential crimes or something like that against.
Yeah, investigating. Like one person I met, I'm not going to say the person's name. They investigated things like genocide and stuff all around the world, and they
Okay.
went into countries, but they dressed in regular clothing, but they went to dangerous territory and they got evidence and stuff like that.
Oh, okay. So they must be investigating like real crimes, like crimes against humanity, those types of crimes.
Yeah,
Okay.
yeah,
Okay. I don't know too much about that. I mean, I'm not shocked about it though at all, but I don't really study that, so I can't really tell you much about it. As far as the job details, description on what they're supposed to do, stuff like that. I can't really tell you much about it. But I would say that it shouldn't be any different than standard detective work. Shouldn't be too much different.
yeah.
Going under the cover, with in civilian clothing, probably get different names or something like that. Probably changing their facial features, probably changing their eye colors, fake fingerprints, stuff like that. So I'm just being hypothetical. I really don't know if that's what they're actually doing, but I don't see why they shouldn't be doing that if they going and investigating stuff like that, because that's very serious stuff.
Yeah. Because I was told that they carry firearms when they do that type of stuff, and they carry handcuffs.
Probably, probably do.
Because I know there's a FBI version that does, like, if an American is harmed in another country or an American harms another foreigner,
Hmm.
that's when the FBI steps out. It's a specific FBI division that goes into other countries if someone is harmed by an American or American is harmed by some foreigner.
Hmm.
They they have a specific one for that with the FBI.
Okay. Okay. I don't really know too much about that, but like I said, I'm not surprised about any of it. To be honest with you, I'm not. None of that stuff surprises me. I actually think that's a good thing, provided that they're actually doing um some good things. Hopefully that's what they're doing and not just using it as a tool to do the exact opposite.
Right. And one of the things I'm going to say to you is a lot of times nowadays you can't depend on the people on the internet, especially specifically YouTube, to go after the actual misconduct of cops, because it's one in a million that do it. But anytime an officer actually does something wrong, you don't get the pushback you would as someone that's actually trying to get a frivolous lawsuit. When you got a person that
I'm sorry.
tries to get a frivolous lawsuit on YouTube,
Uh-huh.
you got people backing that person up. But then when an actual victim of misconduct, um, for someone that they would rather police stop a person for their status, immigration, than to stop someone that's doing something really extremely suspicious with a rifle.
Yeah.
And some of them have even sorry about that. I'm gonna let you speak. Sorry about that.
No, I was gonna say I understand what you're saying. Um, I I'm gonna tell y'all something. I don't know. I'm not sure if I told y'all this, but I regret settling my lawsuit. The reason why I regret it is because nothing would happen to these police officers that I know of,
Yeah,
as far as them being sanctioned, them actually being punished, because
yeah,
the so-called money that I got, that didn't come from them. That came from the city. Those police officers, they were insured by that city. So the city's insurance company paid that lawsuit for them. I think I had a good reason for settling it, and my reason was because I didn't trust that district judge. I did not trust her at all. When you're litigating your case, you're not just going up against these two police officers. You are going up against the bar, because you're not supposed to bring your ass in here, know what you're talking about, and win. You're not supposed to do that. Like, they just, I don't know what's wrong with them people, but they just haters. They real haters. It's like that they are
Yeah.
what they call them gatekeepers or something like that over the over justice. That's what it's like. It's like you have to be one of their colleagues to get damn justice. It's terrible, man. It's terrible. You can file a motion, be 100% right, and they will deny your shit one page, one sentence, and they won't tell you why. And they know exactly. They know that they're wrong for doing that. They know that your lawsuit or whatever it is has merit, and they will still do it. And now you have to go through an appeal. You have to pay probably about $400 or $500 for an appeal. Now you got to draft an appeal brief. Like these people are, they just terrible, man. It's awful. They terrible. They just ooh boy. They get on my damn nerves, man. They get on my nerves. But when you don't have the funds to do it, I mean to hire an attorney, you got to do this shit yourself, man.
Right.
You're gonna have to do it yourself, which means you're gonna have to get your ass up, drive to that law library, or get on a computer and read and study until you just tired or until you have a headache. That's what I did. That's exactly what I did. But they terrible, man. I don't advise anybody. Like if these police officers really did something bad, something that they should be in prison for, I don't advise anybody to settle that lawsuit. Go all the way to trial and hang their ass over, hand them over to the jury and let the jury render judgment against them. And then you need to file not a 42, but a Title 18, 241, 242 criminal affidavit against them, and file it in the United States District Court. And hopefully the magistrate judge and the U.S. attorney do their fucking job. Hopefully.
Yeah.
I had a decent magistrate judge in my case. He treated me. I think he overall on a scale of 1 to 10, I would give him probably about a 7.5 to an 8. I followed all the rules. And when I didn't, he would strike some of my stuff, and he would tell me, "Hey, look, you got to do this." He wouldn't tell me exactly, what rule or whatever, but he would tell me that, like, the mistake that I made. So in other words, he would tell me what I needed to do without telling me what I needed to do. He would just give me little hints and stuff like that.
Right.
He advised me to settle my case. He advised both of the parties to settle the case. We were on the phone talking. He was like, listen, I just think y'all need to settle the case. That was him. As a matter of fact, when I went to the settlement conference, he didn't even have on a robe. He came in there in a business suit. I didn't know who the hell he was. I was waiting to see a damn judge. He came in the courtroom in a business suit. But I don't mean to get off track here, y'all. I do apologize for that, but it's terrible. Terrible. They don't get punished when you settle lawsuits. They don't get punished.
Right.
These people need to be punished. If you're gonna take me to jail for smoking weed, then you need to do something to these motherfuckers for violating federal law, sovereign law, the people's law. They need to be sanctioned for that. And I don't mean just like no little smack on the wrist or no little 90-day suspension or something like they need to be made an example of them. You need to make a public, nationwide example of them when they do stuff like this. They just terrible, man. Terrible, terrible, terrible. Y'all, man, I read cases that's I just throw my hands in there. Sometimes I get mad. I just shake my head and sometimes I just don't do nothing because I'm getting desensitized to it. It's terrible, man.
Yeah, one thing I noticed. Yeah, one thing is a problem nowadays is people will say, "I don't know, I wasn't there," just to when it comes to one side, but then when it comes to another side, it means they'll try to take one person's side. but then when it comes to somebody else, it's like, I don't know, I wasn't there. It's like, make up your mind. Too many people do that nowadays.
Man, these people. I remember one time I asked the judge, the so-called judge. We were in district court, and I said, Your Honor, I said, what makes this officer's testimony more credible than mine? Because you don't have any video evidence. He says I did this. I disputed and say that didn't happen. I did this. So what makes his testimony more credible than mine? This motherfucker couldn't give me no answer. He didn't have one answer for me. Not one. It's y'all. I'm sorry. I have a extremely low tolerance when dealing with these people. Extremely low tolerance because I already know what to expect. That's sad that I already know what to expect when dealing with these people. They don't play fair. They don't play by their own rules. They made this shit up. We didn't make this shit up. They made this up.
Right.
But they don't want to play by their own rules. But they want to hold you to the rules. It's crazy, man. It's crazy. Listen, y'all, I don't advise anybody to settle no case. The only way if you feel like that you're not going to get any justice because they're going to be biased or prejudiced against you or something like that, then yeah, settle the case. At least you get, I guess, something better than nothing. But if you don't feel like that, don't settle that case. And immediately, you need to file a Title 18, 241, 242 lawsuit against them, because if they violate your rights, I don't see how that they don't violate your rights criminally if they do it civilly. It don't make sense to me unless the elements are different.
And one more thing.
Go ahead. I'm sorry.
I was on YouTube, and there was one person that was talking about. I watched stories about Mississippi burning. And this one person that had this black emoji of a woman was talking about the race card and how the white guys got the black activists killed. But then when there was a guy that the same person with the same emoji saw a guy walking suspiciously with a AK-47 with a mask on his face trying to get a lawsuit, she defended him, but this so-called black woman didn't go against the actual thing that was actually in history, where we were actually racially, where the civil rights workers got murdered. She sat there and she defended those officers that did that. And I'm like, who are you? Had I been on the internet, online about that, I would have put her in her place. Man, had I been on YouTube at that time.
When these people show you who they are, believe them. Somebody told me that one day. I think I heard Yusuf say that one day on his channel, Yusuf L, on high frequency radio. When they show you who they are, believe them. But I'm gonna tell y'all, this is the problem, y'all. The reason these public servants are like this, that is the people's fault. It shouldn't be nobody going no work. Do y'all know how much food costs now? I don't even like going to the store to buy food. It's fucking ridiculous. It shouldn't be nobody going to work, nobody paying bills, nobody shouldn't be doing shit. Everybody should be at their state capitals right now until this shit get fixed. This shit don't belong to them. Right. This collectively, this is our shit collectively.
Right.
They don't run the show. Should nobody be doing nothing until this shit gets changed, man. It's terrible, y'all. Like, if y'all think these police officers bad, go read some cases on judicial immunity and see. They worse. Because they can do damn near anything. As long as they got jurisdiction, they can do damn near anything. Which is crazy. It's crazy, man. But can't nobody change that but the sovereign people in these so-called states. Because the sovereign people in these so-called states can change the Constitution whenever they want. They don't have to wait 5 to 6 years to amend the Constitution. They don't have to do that. You can change the Constitution whenever you want. Now, when I say whatever you want, I mean right now, if you want to. Because all 3 branches of government belong to you. You do not belong to them. They are administrative agencies of the people. The law that they are administering is the state constitution. That's what they're administering. That's why they're administrative agencies of the people.
Well, I gotta go now. I appreciate talking with you.
Yeah, same to you, man. Enjoy, man. Enjoy your weekend, man. Be safe.
I will. Thank you.
All right. All right. Now that since I have volume, I'm gonna go ahead. Well, since the microphone is working, let me see how much time I got on this thing. I got enough time. I'm gonna play y'all this video with Casey Neville, the one I was playing earlier. I'll try to skip through it a little bit more to let y'all see it. It's about 10 minutes long. Give me a second. Let me find it right quick, y'all. Here it is, right here. All right, I'm gonna screen share it too.
All right, hey Casey, would you step?
Give me a second. Let me go back. I'm gonna screen share it so y'all can see it.
Step out and talk to us here for a second? All right, hey Casey, would you step out and talk to us here for a second? No?
In Marion, Iowa, these police have no arrest warrant and no probable cause.
I need him to go. Well, he's not going to go anywhere, so.
No.
Yet for trying to close the door...
Come on.
Hey!
You need to come out.
Hey,
come
dude!
Out to us.
Step out dude! Dude!
Step out here!
Get on the ground. On the ground. Hey, you're under arrest. Get on the ground. What's going on? Get on the ground. Get on the ground. What's going on? You're under arrest. For what? For harassment. Harassment on what? What's calling the city hall earlier today?
Yes, calling City Hall earlier in the day. They are arresting and cuffing him not for threatening City Hall, just calling City Hall and asking for documents.
Dude, I called the FBI, I called the U.S. Marshals, I called everybody.
Well, that's brilliant.
No, what's wrong with City Hall?
You've been warned not to harass them.
Dude, that was a year ago on some false harassment.
A year ago on false harassment, the man said, and he is correct. Casey, who goes by the social media name Afroman Audit 365, was arrested at City Hall just over a year before this encounter for allegedly trespassing and harassment. He represented himself at trial and was found not guilty. The judge ruled the city had no right to bar him from City Hall or stop him from doing business there. Now on this day in February 2022, after Casey called City Hall and showed up in person to get public records for use in a civil lawsuit against the police, the cops are arguably retaliating. Casey explains the situation to a friend inside the apartment.
Nah, dude, they're arresting me for harassment. Nah, dude, they're arresting me for harassment, dude. This guy's already arrested me illegally, and I beat him in court a year ago for him lying in court. They're arresting me for standing in public.
Calm down, Casey.
And now all of a sudden,
Where are your
you
shoes?
guys again?
Where are your shoes?
Can you grab the slippers maybe? Grab the
Casey, I'm going to
What
search it. Do you have anything on you need to be aware of?
Don't touch me. I don't give you
No, I'm
consent.
going
You're
to
getting
search you.
searched.
Fourth Amendment right.
No,
I don't
nothing to
give
do with the
consent.
Fourth
I don't
Amendment.
give. Hey, is there
You're being
badge?
seized already,
Dude.
so we're gonna search you, okay?
Dude,
All right, that's the way they is. You're under arrest. So your seizures
I
are.
don't give you consent to my.
Well, that's good.
I do actually.
No, you don't. See,
For an illegal detainment,
It's
yeah.
not illegal. You're under arrest.
Dude, you straight pushed my door open and tackled me.
No,
What
you
do
tried,
mean?
you opened the door, and you tried to shut it.
You dipshit. You stepped in
We're not
there.
talking, okay?
Yep, it's not worth engaging with him at this point.
All right, we're going, let's go.
The body camera video recently released is intriguing from the moment police approached Casey's building. Under the direction of the police chief and against the judge's ruling, the police are planning to arrest Casey.
So we'll wait till 60 gets here.
Okay.
Just pull up right by that red dumpster just so we aren't blocking the drive.
Yeah, okay.
And it's kind of off to the side there.
But they don't have a warrant because they cannot get one. A female officer new to the force inadvertently reveals the unlawful plan when she asks on camera about Mirandizing Casey.
If he's technically what I need to Mirandize him before I ask him any questions.
You're not under arrest at this point, right?
No.
Okay.
But are we?
160-1023.
I'll ask him.
I'm pulling in from First Avenue.
No, he's not under arrest. He can shut the door on us.
He's not under arrest, he can shut the door on us. That's true. If police are not planning to arrest somebody, that person does not have to talk.
Okay.
Let's go down and get a warrant for his arrest then.
Yes, generally police can get a warrant. And once police are making a planned arrest, they must warn the suspect he has the right to remain silent. But in this case, where the cops cannot get a warrant, the police are hoping Casey assaults them by closing the door on their feet.
We're on camera, okay? We're live now. So any statement you make, if you're going to make that statement, then you do have to Mirandize.
Yeah. Okay.
So we're going to go up and get his side of the story, and we're going to go from there.
But the police are not about to get his side of the story. Instead, they put their gloves on for going hands-on. Once inside the building, the police decide to have Kylie McCoy, the rookie female officer, make first contact. This way, Casey doesn't feel threatened or suspect anything.
Hey, Casey. Hey, Casey, can you come to the door and just talk to me for a second? Okay. Listen, man, it's really important that you come talk to us right now, okay?
Who is it? He says.
I'm Officer McCoy. I'm with the Marion Police Department. I'm sorry, I can't hear you, Casey. What you saying? Oh, okay. Can you come to the door and talk to us?
It works. And the police quietly signal to one another down the hallway that Casey is preparing to open the door.
All right. Hey, Casey, would you say...
Hold on, y'all. Now, I want y'all to read this police officer's lips. This officer right here. Now, to me, it looks like he's saying we're going to break our oaths. That's what it looks like he's saying to me. So I'm going to rewind it because I want y'all to see it. It looks like he's saying we're going to break our oaths of office. That's what it looks like he's saying.
Step out and talk to us here. Okay, can you come to the door and stand? Oh, okay. Can you come to the door and talk to us?
It works. And the police quietly signal to one another down the hallway that Casey is preparing to open the door.
All right. Hey, Casey, would you step out and talk to us here for a second? No? Okay.
And I need him to go.
He's not going to go anywhere, so.
No.
Hey!
Come on.
Hey!
You need to come out.
Hey,
come out and talk to us.
Step out
dude!
Step out Get on the ground. On the ground. Hey, you're under arrest. Now get on the ground. Get on the ground. Get on the ground. You're under arrest.
For what?
For harassment.
Harassment on what? What's
Calling City Hall earlier today.
Dude, I called the FBI, I called the U.S. Marshals, I called everybody.
Well, that's brilliant.
No shit. What's wrong with City Hall?
You've been warned not to harass them.
Dude, that was a year ago when some culture.
Sit him up. Put your legs in, Casey. We're gonna wait.
Holy
I'm gonna stand you up, okay?
Ow, Jesus Christ.
You want shoes, Casey?
I'd like to not Yes, shoes at least. Holy
Get your shoes.
Jesus Christ. Holy,
look at me for,
listen to me for,
hey, listen to me for just a second. Is it okay to you gonna listen to me for
Nah, dude, they're arresting me for harassment. Nah, dude, they're arresting me for harassment, dude.
Where are your
This guy's
shoes?
already arrested me illegally, and I beat him in court a year ago for him lying in court.
We're going
arresting me for standing in public.
Calm down, Casey.
Don't touch me. I don't give you
No, I'm going to
You're getting
search you.
searched.
Fourth Amendment right.
Calm down.
I don't
nothing
give
to do with the
consent.
Fourth
I don't
Amendment.
give. Hey,
Well, you're being seized already, so we're going to
Dude.
search you, okay?
Dude.
All right, that's the way that it is. You're under arrest. So your seizure's already been done. You don't need to give us consent.
I do, actually.
No, you don't. So you need to read the law a little bit more.
Detainment.
It's not illegal. You're under arrest.
Dude, you straight pushed my door open and tackled me.
No,
What do you mean?
you opened the door and you tried shutting it on
You
us.
dipshit. You stepped
Okay,
in
we're
there.
done talking, okay? Put your shoes on.
It's not where they need to.
All right, we're going. Let's go.
On the way to the squad car, Officer Joseph Chapman roughed up Casey, causing him to lose a shoe.
This happens if you play games, right?
This is what happens if you play games.
Kid idiot, how am I supposed to walk?
With your feet. One leg in front of the other. That's how you're telling your kid, right?
At this point, Casey looks at Officer Chapman, and Chapman becomes even angry.
You turn and face me again, you have a bigger problem. You understand that? Do you understand me?
Yes, dude.
One leg in front of the other. Sit down. Turn around and face me.
What did he do? He turned around and faced me.
Try to headbutt you?
What?
Did he try to headbutt you?
No, he just tried to turn you. You good? Yeah. Just gonna shut the door.
Casey was booked on 5 counts of harassment and held briefly at the local jail before being released on his own recognizance. Legal experts call the charges against him absurd. Furthermore, the experts say the body camera videos clearly established that the police committed assault and battery, kidnapping, and violated Casey's First, Fourth, and 14th Amendment rights. And all because Casey, Afro Man Audit 365, previously humiliated police in court, got his rights affirmed, and started asking City Hall employees for documents and information relevant to a potential lawsuit against police. Over the past several years, I've reported on a lot of horrific law enforcement departments and shameful cops, but the officers in Marion, Iowa, from the chief on down, are clearly among the worst. One can only hope that Casey brings a lawsuit that literally bankrupts that city. In the meantime, the police are not commenting on any of this. To be clear, I'm sure there are some good people in Marion, Iowa, and perhaps there are even a few city employees who honor information requests and public access as the law requires instead of freaking out. Still, the good people in Marion deserve far better than city workers who are ignorant, and far more than a tyrannical police department that is rotten to its core. I'm David Schuster. Thanks for joining us.
All right, that's the end of that video, y'all. I'm gonna look at the chat right now. Somebody said, JR says, where can I find this original video? Okay, let me go to my YouTube channel. Because Casey, I did a video on it, and Casey, this video right here, he commented on it. So give me a second, JR. Let me turn that volume down just in case. This is his channel right here, JR. Right here. So I'm gonna go ahead and click on it. But anyway, let me I typed him some comments. I think there's supposed to be some more comments because I think he told me that they did this to him maybe 2 or 3 more times, if I'm not mistaken, but I want to be sure. So let me see if I can find it. Yeah, here it is right here. It says 3 days ago, I'm working on it. They have arrested me 3 more times since this incident and burying me in trumped up charges. That's what they'll do, y'all. They will do that. I'm not joking. They will do that, making it difficult for me to focus on the litigation side of things. But I do have one suit filed, and there's his case number right there. I'm not. That looks like a state court case number. I don't think that's federal. I could be wrong, but I don't think it's federal. But let me go ahead and show you. This is his YouTube channel. See if you can find the original video. Let's see. Okay, so I'm not sure if his video is actually on here. It's probably not. His video is probably not on here. So it looks like he's just he's just posting other videos of. Wait a minute, hold on. This might be his right here. Yeah, that's his video right there. 13 minutes. 13 minutes or something. So JR, if you wanted to go and look, this is his YouTube channel right up here. And this is his I'm assuming he did this video right here. I'm just gonna guess. I don't really know. But that's how you find it. Let me go back to the comment section and see what's going on. Hey Jerome, you stupid, man. I'm sorry to hear that though, man. But hey, that is funny. Well, it's not funny, but I get what you're saying, man. I get it. So you can vouch for him, huh? You can you can vouch for him. Oh boy. Excuse me, y'all. All right, let me what did I wanted to show y'all something. I forgot what it was though. Let me go back. I'm gonna turn the screen share off and I'm gonna get back to the phone lines and see. Oh boy. Boy, you a trip, Jerome. You funny, man. I got about 9 minutes on the air. So if you want to call in, you can call in. I got about 9 more minutes on the air. Oh boy. Boy. Okay. So like, do anybody have any questions in regards to you litigating cases right now in state court? Excuse me. Matter of fact, do I want to do that? Um, yeah, let me do something. I'm gonna make sure because I'm gonna show y'all the complaint that I'm working on for somebody, but I'm gonna make sure that. Well, you know what? No, because it has the officers' names in it, and I don't want to do that. Not right now. So I'm not gonna do that. But I'm working on a complaint for somebody, and like I said, they basically made materially false inculpatory statements against him. They withheld exculpatory evidence from him to try to get him convicted for 3 felonies. Long story short, he ended up beating the case on a motion to suppress hearing. Um, and once he won the motion to suppress, the prosecution moved for an oral motion to null pros the case, and so now he's suing him. Um, I'm gonna I'm gonna share this case with y'all. So, do any of y'all have any you good, bro? Keep that tight. Let me see. I think you support. I think you asked me a question. Let me go and see. I think somebody asked me a question in my community section. I gotta go and see what it was. Cause I'm sorry. I be so busy sometimes, y'all. Let's see. Yeah, it says, in your opinion, what is the most tedious part of preparing a federal lawsuit outside of case law research? Preparing the lawsuit, in my opinion, is pretty easy. I like right now, I don't have to leave my house to draft a lawsuit. I don't have to leave at all. But you said outside of law and research. So if it's outside of law and research, but you saying preparing the lawsuit, um, I would say nothing. But now when you talk about litigating the lawsuit, I would say discovery because when you're going through discovery, they not gonna just give you what you asking for willingly. Like they gonna make you work for that shit. Like they might make up a laundry list of meritless objections so that they won't give you this. So they don't have to well let me rephrase that. So they can stall out a little longer on giving you the evidence that you need to make your case because I know y'all probably don't know this, but in the ultimate facts section of your complaint, they're really just allegations. all you're doing is making allegations first. Once these allegations are considered, and the judge, whoever looks at it, the magistrate judge or the U.S. district judge, whatever, once they look at it and see that a right has been violated, um, these officers are not going to get immunity once they see that they're not entitled to qualified immunity. So once you make it past that stage, and then you go to a Rule 12 scheduling conference, I think that's what it is. That a Rule 12 scheduling conference is where you actually meet with their attorney and y'all discuss the entire case, like how many sets of interrogatories you're gonna get, requests for admissions, how many depositions you're gonna get, how long are the depositions, when is the trial date, how many days will the trial take, um, when will discovery start, when will discovery end. So it's just a bunch of stuff. Um, After that, then you just going through discovery. And discovery, I remember one time, like I said earlier, um, I was asking for evidence because you're asking for evidence in support of your claim, in support of your allegations and your complaint. So all the evidence that you're asking for, it needs to be relevant to proving the allegations in your complaint. So I was asking for I remember I asked this attorney for his client's financial information. And he made up some BS excuses, and then he flat out told me after I had to I think we had to go through some what do they call it, position papers, something like that. I got him on the phone. We started talking about it, and he just flat out said, "I'm not going to give you my client's financial information." And I was like, "All right." And so he didn't give it to me. We literally had to schedule a call with the judge so I can get this financial information. The judge ordered him to give it to me, though, by the way. But it's just little tedious stuff like that. They don't make this stuff easy for you, which I get it, because he's an attorney. He's he don't want his clients to think that he's just he's not fighting for their rights and stuff like that, or whatever you want to get. Whatever you want to call it. So I get it, but it's just the fact that you just have to go through that little tedious stuff. Like these people will knowingly, they'll knowingly file a meritless motion for summary judgment, misrepresent all of the facts in the case. Let me rephrase that: misrepresent all of the material facts in the case, meaning the facts that actually can determine whether if the case is ruled in their favor or your favor. They will actually do that. They will actually do that. That's what they did in my case. But we never made it to the but before I got a chance to file my my response in opposition to their motion for summary judgment, we just settled the case. But it's really discovery, in my opinion. It's discovery. That is sometimes that's the longest part of the case. That depends on what it is. Like, you might be going through discovery for years. Mine only took probably about 6 to 8 months. So it didn't take too long, but like 6 months to be going through discovery, in my opinion, that's long to be going through discovery, in my opinion. Let me get back to the chat and see what's going on. Make sure I ain't missed nothing.
90 seconds.
All right, cool, JR. So did you use e-filing or mail? I used e-filing support. That's what I did. So what you can do is, when you go to that Rule 12 scheduling conference, when you talk to the attorney, what I did was, it was just easier for me. I was like, look, man, I'm gonna stipulate to service by email, meaning you can serve me all
60 seconds
that I need to see that you're trying to get admitted into evidence. You can just send it to my email address, and we'll just, you can just, say it's served like that. You know what I'm saying? Unless I tell you I didn't get it, something like that. But I got all my stuff via email. And then once I got the documents or whatever, I think, I'm not sure if the court had to approve it or I don't really know, but I e-filed all of my documents. I think I might have went down to court maybe once or twice throughout the entire process of me litigating my lawsuit. Have a certificate of protest for a client and seeking summary judgment for a consumer claim.
10 seconds.
Let me go ahead and end that. What do you mean support? You said you have a certificate of protest for a client and seeking summary judgment. Are you litigating the case for somebody? You helping somebody out? But Jerome, you funny, man. Jerome said you looked at me. Yeah, man. They're like, these people think that these people really think that you are beneath them. They do not think that we are on equal. Let me rephrase that, because we're not on equal footing to them because they're public servants. I need help because okay. You need help because you have a certificate of protest for a client and seeking a summary judgment for a consumer claim. Okay. Do you know how to beat summary judgment support? How you doing, Miss G? I wish you would have called in, Miss G. Let me see. For some reason, it's hiding, it's restricting your comments, Miss G. I don't know why. It says it's retracted or something like that. Dave Schuster does good reporting. No corpus delicti means no probable cause, no victim. So sorry. Yeah, that's another way to look at it. Yeah. That's another way to look at it. And this. There's a I think I'm gonna read that case on here. I'll probably read it tonight because I think I'm not gonna read the entire case, but I actually just found this out I think today, and I think it's relevant. I think it's important. My client is the plaintiff and has completed an administrative process and has a certificate of protest as evidence and facts. Oh, so you're moving for summary judgment. That's what you're saying. So you want your client, you want to move for summary judgment for your client. Would that be correct? If that's correct, do you have the evidence in support of your motion for summary judgment? Okay, so if you have the evidence, then now you need to find the case law. Find the case law in support of your evidence to move for summary judgment. So basically, the standard, if I'm not mistaken, is a movement, meaning the person moving for summary judgment, is entitled to summary judgment if you can show that there is no genuine issue of a material fact in dispute, and you are entitled to that judgment as a matter of law, meaning the law is, let's say, it's like this. Okay, well, based on these facts and this case law, you have to explain the court to, like, this is how they have to rule. In other words, you're directing them, you're telling them, you are compelling them to rule on this way in your case because the law as applied to the facts say that they have to rule this way. I tried to explain it to y'all without confusing y'all. What about the 83? What do you mean the 83, Miss G? What do you mean? I want to share something with y'all too. I'm gonna screen share it and share it with y'all. In case y'all didn't know, because I didn't even know this. The guy who I'm helping, he actually gave me this case today. So I'm not gonna read all of it. I'm just gonna read the important parts, which is what they held, because I think that's very important, because they're known to no pross a case, and they won't tell you why they no pross the case. But before this court opinion that they just issued, you used to couldn't sue them if they know pross the case in some of the in some places of the country, unless um you got a some sort of adjudicative express ruling or something like that, stating that you were innocent of the so-called crime. The one issue is contemplating on whether or not to hire a bar attorney. Don't want to, but I cannot represent the client on his behalf. Yeah, you're gonna have to then, or you can explain it to him, she or he or whatever. You can explain it to them and let them go in there and do it if they're capable of doing it. Let me read. Let me find this case right quick, and I'm gonna read it to you. What they held. Where's the? I gotta find the holding. I think this is it. This case requires us to flesh out a favorable determination. Does it suffice for a plaintiff to show that his criminal prosecution was conviction? Or must the plaintiff demonstrate that the prosecution ended with some firm, such as an acquittal or dismissal? Sufficient. We conclude as follows to them. Okay, yeah. So I'm gonna read y'all what's important. What's important is what was held in this case. I'm gonna screen share it and I'm gonna show you. I'll be back to the comment section in a minute, y'all. Give me a second. All right. Okay. All right. So this is they did this April of last year. I didn't even know this until today, y'all. Just to let y'all know. Thompson versus Clark. So I went through the case. I read probably about maybe 80% of the case. And I'm going to read y'all what is highlighted. Justice Kavanaugh delivered the opinion of the court. Larry Thompson was charged and detained in state criminal proceedings, but the charges were dismissed before trial without any explanation by the prosecutor or judge. They will do that. They don't want to tell you nothing. After the dismissal, Thompson alleged that the police officers who initiated the criminal proceedings had maliciously prosecuted him without probable cause. Thompson sued and sought money damages from the officers in federal court. As relevant here, he advanced a Fourth Amendment claim under 42 Section 1983. He could have had more causes of actions against that. He probably did. To maintain that Fourth Amendment claim under 42 Section 1983, before they decided this case, a plaintiff such as Thompson must demonstrate, among other things, that he obtained a favorable termination of the underlying criminal prosecution. And this is where Heck v. Humphrey comes in at. So in other words, before they ruled on this case right here, if he did not get a favorable termination in his case stating that he was innocent, something like that. Well, I'll read it a little bit more because I don't want to confuse y'all. The case explains it anyway. This case requires us to flesh out what a favorable determination entails. Does it suffice for a plaintiff to show that his criminal prosecution ended without a conviction? Or must the plaintiff also demonstrate that the prosecution ended with some affirmative indication of his innocence, such as an acquittal or a dismissal accompanied by a statement from the judge that the evidence was insufficient. We conclude as follows: to demonstrate a favorable termination, of a criminal prosecution for purposes of the Fourth Amendment claim under 42 Section 1983 for malicious prosecution, a plaintiff need only show that his prosecution ended without a conviction. That's all you need to show. You don't have to show that you was innocent or anything like that. Right now, that's the standing case law. There's something I want y'all to see. So give me a second, because I want to share that case with y'all. I'm gonna turn screen share off right quick. Give me a second until I find this. I made a mistake trying to do a lawsuit and put in wrong court, and they said it nothing to do with the case, denied it, and took my house, took my son's house. They evicted everybody. What? I hate you going through that, Miss G. I really do, because that will, based on what you were telling me, that was a valid will. Based on what you're telling me, man, I just hate you. I can't stand these people. These people get on my damn nerves, man. They get on my fucking nerves when they do stuff like this to people. Let me pull up this case right quick. Yeah, I'm gonna get off. I'm not gonna be on here all night. I got a headache right now. But I'm gonna read this one. Okay. So where is that argument at? It's gonna be down. I think it was a malicious. Was it a malicious prosecution claim? I think it was. Yeah, I think it's this right here. But this case was decided before they decided the case that I just read. So you're not gonna see that in here. Was that it? Let me see something. Individual capacity. I'm trying to find official capacity. Fund report turns the department lays prosecution claim against the city department. Freestanding state analysis, prosecution. Therefore, Bonnie cannot persuade federal prosecution claim. As Bonnie lays prosecution claim are based on state law, the statute of limitation board. Therefore, to the extent born asserts in this prosecution claim, you have to defend the statute of limitation board these claims. Where is it at? It's somewhere up here. I think I might have got the wrong case, y'all. That's the Monell claim. We're not talking about Monell right now. Springs, bars, extension and fabricating that's claim based on directly challenge written. Although my dogs are Fourth Amendment, rather than Fourth Amendment, it's applicable to heck applies to the claims if I have. Okay, yeah. This is it. So let me get back to the chat right quick. This Kate Thompson versus Clark. Man, I ain't even know about that case, JR. They turned your paperwork into a motion. Well, Miss G, they probably did that, Miss G, because it's substance over form. So it doesn't matter what the title of the document is. It matters what you are asking for in the document. If the judge is still a member of the bar, then he's wearing two hats and practicing law from the bench. Wouldn't a securitization audit be effective in removing him? To be honest with you, I'm not qualified to answer that question. I can tell you that they are wearing two hats, though. I can tell you that they're probably wearing three hats. Ain't no telling. If you ask me, they're wearing a so-called judicial hat, but it's not just the judge doing that either. A lot of them are doing that. He's wearing a executive hat, and he's wearing a so-called legislative hat. Like when you go to court, let's say you go to court, and there are rules in this court, like say you can't wear a tank top in here, or you can't wear certain types of clothes in court, or something like that. That rule has the same effect as the so-called law. So essentially, what I'm trying to get you to understand is you're an administrative agent. It's an administrative agency. That's where you at. That rule that they made up, it has the same effect as the so-called law, even though it's not law. It's quasi-legislative, or so to speak. I don't. Well, Jr. They just did that case last year. Yeah, a little over a year ago. Yeah, somebody else might be more qualified to answer that, Chief. But yeah, they're all wearing multiple hats. All of them. They're wearing multiple hats. It's very confusing too, by the way, because you don't know who you're dealing with unless you're looking at the paperwork to determine the um the nature of the action, and you're looking at the remedy that the plaintiff is asking for. It's very confusing, in my opinion. It is very confusing unless you can use that to to your advantage to understand what's going on. Um, let's see. All right, I'm gonna read this. Uh, this is new to me, but it's interesting. So I'm gonna read this to y'all because this may be applicable to somebody one day that's on my channel looking for some information. So let me go back to screen share. I'm gonna turn the camera off and we're gonna screen share. All right. A Fourth Amendment claim for wrongful pretrial determination accrues when the wrongful detention ends. Because Barnett has alleged that false statements provided the basis for probable cause determination against him, he has alleged that his detention remained wrongful even after he was formally charged. Detention predicated solely on police officers' false statement violates the Fourth Amendment, even after the onset of legal process. In such cases, wrongful detention claims based on falsified probable cause accrue upon the detainee's release. But hold on, y'all. Hold on. Because they're going to toll this cause of action that he has against these police officers. Because he can't sue them right now for that because his claims are heck barred. They're barred by Heck v. Humphrey that I just read in that other case. Barnett's amended complaint reveals that he was released from custody on October 1st, 2016, more than 2 years before he filed his complaint. But the court must also consider the effect of ongoing criminal proceedings on Barnett's ability to bring suit on his wrongful detention claim. See that right there, Heck v. Humphrey? That's what they got to do. Barnett could not bring a Section 1983 suit concerning his confinement until the criminal proceedings terminated in his favor if the suit would necessarily imply the invalidity of an outstanding criminal conviction or sentence. In McDonough, the Supreme Court emphasized that the Heck bar extends to fabrication of evidence claim based on evidence used to secure an indictment, given that such a claim directly challenges and thus necessarily threatens to impugn the prosecution itself. Although McDonough or whatever, however you pronounce it, concerned a 14th Amendment fabrication of evidence claim rather than one based in the Fourth Amendment, its application to Heck applies to Barnett's Fourth Amendment claim. If, however, a conclusion that Sanders' confinement was unconstitutional would imply the invalidity of an ongoing criminal proceeding or a prior criminal conviction, then Heck would continue to bar Sanders' claim after his release and until either those proceedings terminated in his favor or the conviction vacated. So in other words, like for example, let's say you get convicted of something 10 years ago, but you get a new trial, you get retried all over again, and then you get adjudicated not guilty. You can sue what happened 10 years ago because under Heck v. Humphrey, you're precluded from litigating that case. So since you're precluded from litigating the case, it's like it's tolled. Toll. It'll toll it. Here, Barnett alleges that the Chicago police had no information to lead them to believe that Barnett had committed a crime. Aside from the false assertions in the arrest report, Barnett's wrongful detention claim centers on evidence used to secure, an indictment at a criminal trial, and so directly challenges and thus necessarily threatens to impugn the prosecution itself. Accrual date for unlawful detention claim based on fabrication of evidence governed by Heck. This means that the claim did not accrue, or whatever you want to call it, accrue until Barnett's acquittal on December 2nd, 2016, making the filing of his complaint on December 3rd, 2018 timely. Unlawful pretrial detention claim based on fabricated evidence did not accrue until the plaintiff's sentence was vacated and charges were dismissed. It's told. Therefore, the statute of limitations does not bar Barnett's wrongful detention claim based on fabrication of evidence. That is a good case. That's a good argument. I'm curious to see what would change based off what I just read in regards to Thompson v. Clark. He wearing a friendship hat. Appreciate it. Man, that's why I filed malicious prosecution in any case with a criminal complaint in state. Hold on, let me see. Oh, J.O. He says that's why I file malicious prosecution in any case with a criminal complaint in state is this okay? In any case, when the criminal complaint in state is dismissed, man, you need to go. It's not just a malicious prosecution claim; it's all that because it's like they violated all your rights. That's assault, battery. It wouldn't be considered a deprivation of liberty. Well, I mean, temporary, yeah, but I mean that would be it wouldn't be a due process claim. It would be a Fourth Amendment claim of an unlawful imprisonment, something like that. In April 2022, up to 10 years or later to still file a complaint. What do you mean, support? I'm a little lost. What do you mean? How long have I been on? I've been on here almost 3 hours. I was not coming on here. I was not planning on staying on here for 3 hours, y'all. They turn my paper to motion. Man, I forgot I was screen sharing, but this is a good case, y'all. This is a very good case. So this is why you need to read cases because this is how you get around statutes of limitations. That's why I just read this to y'all because this allows you if you're filing lawsuits against these people and you're late sometimes, so-called late, this will allow your lawsuit to proceed if you file it beyond the statutes of limitations, because that's what they tried to argue in this case. They tried to argue that his him filing this lawsuit was untimely. Let me get back. I'm gonna turn the screen share off. Turn the camera back on. I'm about to get off here, y'all. I'm tired. Was he able to file up to 10 years, or is there no statute of limitations? Up to 10 years? I don't understand your question, support. What do you mean? Are you talking about the case that I just read with him filing his lawsuit? Was it late or something like that? Is that what you're saying? Let me go back and see. Let me see. Was he able to? It's 2 years in that case. In that case, I think it's 2 years. Let me see. What about tort claims? Let me see something. He was released from custody in 2016. But he didn't file this lawsuit did not get filed until 2020, y'all. Just to let y'all know. Let me go back up because I'm gonna screen share it again because I forgot to tell y'all some stuff about it. So I'm gonna screen share it again. Okay. So let's go back up. I'm gonna tell y'all some of the facts. Okay. This happened in 20. He started litigating the case in 2020. If I'm not mistaken, let me hold on. Let me go back down. I think he started litigating this case in 2018. Let me see something. So I might be wrong. Where is it at? I might have just. I think I just passed it. Where is it at? I'm trying to find it, y'all. Give me a second. Statute of limitations. Barnett he was released from custody October 1st, 2016. 2016. This means that the claim he was released from custody in October. This means that the claim did not accrue until Barnett's acquittal on December 2nd, 2016, making filing of his complaint on December 3rd, 2018 timely. Where's that footnote at? Let me see what that footnote says. For Federal Rule Civil Procedure 681C, when computing time, the court must include the last day. Oh, okay, that's why they did that. The last day of the period. But if the last day is a Saturday, Sunday, or legal holiday, the period continues to run until the next day. Okay, that's why they did that. Okay. But I need to go back up and read what happened. So I think I left out some stuff. I don't see any dates on here. I'm looking for the dates. Okay, right here. On or about September 28, 2016, Harry Bennett bought an inoperative scooter from his former co-worker Daniel Santos for $60. After Barnett listed the scooter for sale on Craigslist, he was contacted by an interested buyer, including Chicago police officer Alexander Kaliski or whatever. Barnett and Kaliski arranged to meet on September 30th, 2016, so that Kaliski could view the scooter. Kaliski believed his own scooter had been stolen, and that the scooter in Barnett's possession was his stolen property. After viewing the scooter, Kaliski and other these cases be funny as hell sometimes, y'all. Kaliski, or however you pronounce that, and other Chicago police officers arrested Barnett based on his possession of the stolen scooter and took him to a police station. Kalinsky and other police officers questioned Barnett, who provided them with contact information for Santos as well as documentation of his purchase of the scooter from Santos. Kalinsky then prepared an arrest report in which he stated that Barnett made no attempt to identify the owner and failed to take reasonable measures to restore the property to the owner, intending to deprive the owner permanently of use. Blah blah blah. Bennett asserts that he was never asked about anything that would lead Kalinsky to believe those facts. Based on the arrest report, superior officers approved probable cause for Barnett's arrest and detention on the charge of theft of lost, mislaid property. So he was formally charged September 30th, 2016, and he was detained until 3 a.m. October 1st, 2016. The judge released for Barnes on an I-bond. So I'm guessing that no, that's not a recognizance. That required him to petition the court for permission to leave Illinois. The judge denied his request for permission to travel to his home, Florida. At some point between his release on December 2nd, 2016, Barnett met with the prosecutor on his case. Cook County Assistant Attorney Angelica Griffin Johnson worked under the state's defendants. Blah blah blah. So this was in this started in 2016. I wonder why is this opinion on here for 2020? They must have been litigating that case for that long. They had to be. They had to be litigating this case for 2 years. I'm not sure if they settled it or what, but it's 2 years. Let's see. What about tort claims? Well, you know I'm going to hit them with bare minimum 20 counts. JR, you a fool, boy. Super familiar. Yeah, that's Joseph, I'm sorry. Y'all looking at a black screen? I'm sorry, man. I didn't turn the screen. Oh my God. Man, I'm sorry, man. Why y'all didn't tell me? I'm so sorry, y'all. I'm sorry, y'all. I did not know the screen was black when I was reading. I'm so sorry, y'all. This is the case that I was reading right here, y'all. I'm so sorry. I did not know that. I thought I turned the screen share on, y'all. My apologies. I did not know that. But this is the case what I was reading right. I'm gonna show you the case, Joseph. This is the case right here. This is the case that I'm gonna send you. This is the case I'm gonna send you. That I was talking to you about earlier today. This is the case. It's very, very similar to yours. Very similar. Man, damn screen black as hell, man. I'm sorry, y'all. Sorry about that. Anyway, y'all, I need to get off here, man. I've been on here 3 hours, 3 damn hours. Ugh, I'm tired, y'all. I gotta go. I got a headache now, y'all. I really do. Before I leave, do anybody have any more questions? Any more questions before I leave? If you haven't, hit that like button. Stop being stingy with that like button. If you haven't already, go ahead and hit that like button. And I really appreciate it if you did. Any more questions before I go, y'all? I'm going to turn screen share off and just get back to the camera. Any more questions? I'm about to get on up out of here because I'm tired, y'all. How do you stay healthy while learning? Man, sometimes I don't eat meat often. Support. I don't. And when I do eat it, I eat lamb. Lamb, lamb. Um, I also I jog sometimes. I go jogging. Um, I try to stay away from sugar and processed foods. I try my best, but that sugar got me, y'all. It's got me in a chokehold. But I've been doing good. Been doing good. I try to eat a lot of fruit and everything like that too. Cause I've been a vegetarian before I started back eating meat. Probably about 12 or 13 years. I just started back eating meat this year. Probably about maybe 6 months ago. 6 to 8 months ago. I just started back eating meat, but I don't eat it often. Ugh. All right, y'all. Well, everybody enjoy your weekend. Be safe. If you get stopped by the police, um, shut up, play dumb, look at name tags, and remember everything. What's what's the state fruit in Alabama? Hell, I don't even I don't know. Support. I don't even know, man. I don't know. I got to get up off here, man. We get up off here, y'all. I'm tired. Everybody enjoy your night, man. Good night.